Before we begin, a quick and important disclaimer. The following content is provided strictly for educational and entertainment purposes. It does not constitute legal, psychological, financial, or professional advice of any kind. Family law, custody regulations, and social services are subject to complex local, state, and federal statutes that vary significantly. The historical trends and case studies discussed are for contextual analysis only. Viewers are strongly encouraged to conduct their own due diligence and consult with licensed legal or mental health professionals regarding their specific personal or legal circumstances. Imagine for a second that you are standing in a courtroom in 1840. You are a father seeking a divorce. In this era, there is no question about where your children will go. They stay with you, not because of a deep psychological bond or a best interest hearing, but because, under the eyes of the law, your children are considered your economic assets and your legal property. Now, flash forward to the present day in the United States. You are a divorced father sitting in a parked car outside a suburban home, at a digital clock, waiting for the exact minute your visitation begins. In less than 2 centuries, the American father has transitioned from the absolute legal son around which the family orbited to a visitor in his own biological lineage. This isn't just a personal tragedy for millions of men. It is a historical anomaly. We are currently living through a period where the abstract concept of family is being rewritten in real time, often leaving the American father in a state of ambiguous loss, a psychological term for grieving someone who is still alive. If you have ever felt like the system was designed to keep you at arm's length, or if you've struggled to define what your role even is when you no longer share a roof with your children, you aren't just imagining the friction. You are feeling the weight of 3 centuries of shifting legal definitions and social engineering. Today, we are embarking on a 10-part deep dive into the historical autopsy of the American fatherhood. By the end of this masterclass, you will understand the specific historical levers, from the Industrial Revolution to the no-fault divorce era, that moved the goalposts on what it means to be a dad. We are going to solve the problem of identity clarity. We are going to move past the surface-level frustration and analyze the data to show you exactly how the abstract family was constructed, and why understanding this history is your only way to reclaim your narrative in the modern age. To understand where we are, we must first dismantle the myth of the timeless family. Most people believe the nuclear family, mom, dad, 2 kids, and a dog, is the natural state of humanity. In reality, that specific model is a relatively modern invention, peaking only in the mid-20th century. For most of American history, the family was an economic unit of production rather than an emotional unit of consumption. In the colonial and early federal periods, the father's role was grounded in patria potestas, a Roman-derived concept of paternal power. If you were a father in 1790, you were the primary educator, the religious head, and the sole legal guardian. The abstract concept of family back then was a hierarchy. Mothers were seen as caregivers for infants, but as soon as a child reached the age of reason, usually around 7, the father took over their moral and vocational development. The first major shift occurred with the Industrial Revolution. This is where the abstract family began to fracture for men. Before factories, dads worked the land alongside their children. The transition to the breadwinner model was the first step in the historical distancing of fathers. As men moved into factories and offices, they became physically absent providers. This created a vacuum in the home that the legal system quickly filled with a new doctrine, the tender years doctrine. Emerging in the mid-19th century, this was a radical departure from history. It suggested that, during their tender years, children had a biological necessity to be with their mothers. This was the first time in U.S. history that the law began to systematically favor the maternal bond over the paternal legal right. For the divorced dad of 1850, this was the beginning of the visitor era. Let's look at a case study from the 19th century to illustrate this. In the landmark British case King versus de Neville, which heavily influenced early American law, a father's right to his child was absolute, even if he was an immigrant or a bad husband. However, as the Victorian era progressed, judges began to use judicial discretion to decide that the moral welfare of the child might reside with the mother. This sounds compassionate, but for fathers, it shifted the definition of family from a legal right to a conditional privilege granted by the state. The father was no longer the owner of his lineage. He was an applicant for time with it. As we move into the early 20th century, the best interests of the child standard began to solidify. On the surface, this sounds like an objective, noble goal. But historically, Best interest has always been a mirror for whatever social values are dominant at the time. In the 1920s, it meant placing children with a parent who could provide the most moral and religious stability. By the 1950s, it meant the parent who could provide the most stable nuclear environment. This period created the fatherhood paradox. Society demanded that men be the sole financial anchors, the breadwinners, but by doing so, it ensured they were the parent with the least amount of face time with the children. When divorce occurred in the 1950s, the courts looked at who did the daily chores, the feeding, and the schooling. Because the social structure forced the father to be away at work, the best interest standard almost always defaulted to the mother. The father was effectively penalized for fulfilling the very role society demanded of him. This brings us to the most volatile shift in the history of the abstract family, the 1970 no-fault divorce revolution. Before 1970, you had to prove fault, adultery, cruelty, or abandonment to get a divorce. This meant that the family unit had a high legal barrier for entry and exit. When California passed the first no-fault divorce law, it fundamentally changed the family from a permanent social contract into an at-will association. For divorced fathers, this was a double-edged sword. While it allowed men to leave toxic marriages, it also created a scenario where the family could be dissolved without a father's consent. Yet his financial obligations, rooted in that old 19th century breadwinner model, remained intact. This created a legal limbo that we are still navigating in 2026. The modern divorced father is often caught between two conflicting historical eras. He is expected to be an equal parent, a 21st century ideal, while often being treated by the court system as a secondary provider, a 20th century relic. This conflict is what makes the concept of family feel so abstract and frustrating today. It's why you might feel like a parent one weekend and a wallet the next. You are living in the friction of 200 years of contradictory laws. In this deep dive, we are going to look at the data regarding sole versus joint custody trends over the last 50 years. We will examine how the child support system was originally designed as a poverty reduction tool for the state, not necessarily as a holistic support system for the family unit. We will analyze how the rise of psychological parent theory in the 1970s further complicated the father's role by prioritizing continuous care over biological connection. This is the promise of this series. We are going to give you the historical vocabulary to describe exactly what has happened to the American father. When you understand that your current struggle isn't a personal failure, but the result of a massive 200-year shift in the legal definition of family, you gain a level of stoic clarity. You stop fighting the ghosts of the past and start navigating the reality of the present. We are going to look at potential outcomes for the new fatherhood and examine case studies of men who have successfully navigated this abstract landscape by redefining their role outside of the traditional nuclear box. This is the masterclass on the evolution of the American dad. Welcome to part 1. To understand how we arrived at the current landscape for divorced fathers in 2026, we have to look at the massive tectonic shift that occurred between 1830 and 1920. This was the era where the abstract concept of family moved from being a property-based hierarchy to a sentiment-based structure. In part 1, we touched on the concept of patria potestas, where the father was the legal son. But as the 19th century progressed, a new legal ideology began to emerge that would eventually sideline fathers for over a century. This was the tender years doctrine. Imagine a man named Thomas in 1885. Thomas is a stonecutter in Pennsylvania. He works 10 hours a day to provide for his wife and 3 children. In the eyes of the law at the start of that century, Thomas was the sole guardian. If a separation occurred, the children stayed with him because he held the deed to the home and the means of production. But by 1885, the social fabric of the United States was changing. The rise of the Industrial Revolution meant that fathers like Thomas were no longer working on the family farm where their children could see them. They were disappearing into factories and quarries. This physical absence created a psychological opening in the legal system. Judges began to buy into the Victorian ideal of the cult of domesticity. This was the belief that women were inherently more moral, more nurturing, and more spiritually connected to children than men. For a divorced father in this era, this was the first time the state stepped in to say that a biological or legal right was secondary to an emotional one. The tender years doctrine established a legal presumption that during a child's young years, usually up to age 7, the mother was the natural custodian. This wasn't based on data or case studies of parenting success. It was based on an abstract, romanticized view of motherhood that stripped the father of his historical role as the primary moral educator. Step by step, the legal system began to dismantle the father's authority. First, courts began to grant mothers custody if the father was proven to be at fault for the divorce. Then they moved the goalposts further, granting custody to mothers even when no fault was found, simply because of the child's age. By the early 1900s, the transition was nearly complete. The father had gone from the head of the household to the financier of the household. Now let's fast forward to the mid-20th century, specifically the post-World War II era. Imagine a father named Robert in 1955. Robert is the quintessential American dad. He has a steady job, a house in the suburbs, and he believes he is building a legacy. But Robert is living in the peak of the breadwinner homemaker model. In this version of the abstract family, the father's value is measured almost exclusively by his paycheck. The legal system during this time codified this. If Robert and his wife divorced in 1955, the court didn't ask who was better at helping with homework or who knew the children's favorite foods. The court looked at the established domestic roles. Since Robert was at the office for 50 hours a week, the court viewed him as an auxiliary parent. This period introduced the best interests of the child standard. On paper, this was supposed to be a neutral way for judges to decide custody. In practice, it was heavily biased toward the status quo. In Robert's case, the status quo was that he worked and his wife stayed home. Therefore, the best interests of the child were seen as maintaining that maternal care, while Robert's role was reduced to providing the capital to make that care possible. This is where the concept of visitation really took root. The father was no longer a parent in the full sense of the word. He was a guest in his children's lives, scheduled for every other weekend and a few hours on Wednesday nights. The data from this era shows a staggering trend. Between 1900 and 1960, the percentage of custody cases favoring mothers rose from a minority to over 90%. This wasn't just a legal shift, it was a cultural one. The American public began to view the father as an optional character in the emotional development of the child. We can see the fallout of this in the 1970s with the introduction of the Uniform Marriage and Divorce Act. This act was meant to modernize the process, but it largely cemented the role of the father as a secondary figure. By the time we reach the late 20th century, we see the rise of the psychological parent theory. This theory suggested that children need one primary, stable figure to bond with, and that adding a second, equal parent after a divorce could cause confusion or instability. This was used as a historical lever to deny joint custody requests for decades. Fathers were told that for the sake of the child's mental health, they should step back and let the mother lead. This created a generation of men who felt like they were paying for a family they weren't allowed to lead. Now, consider the world of 2026. Imagine a father named Mark. Mark is a modern, involved dad. He changed diapers, he attended every doctor's appointment, and he works from home. In 2026, the abstract concept of family has shifted again, but Mark is still haunted by the ghosts of the tender years doctrine and the breadwinner model. Even though 34 states have now passed some form of legislation encouraging or presuming 50-50 joint physical custody, the institutional inertia of the last 150 years remains. Mark has to use high-conflict parenting apps to log his every interaction. He has to present spreadsheets to prove he is providing an equal amount of care. The abstract family for Mark is no longer a hierarchy or a romanticized unit. It is a series of data points managed by a legal portal. The historical trends show that while we are moving toward equality, the system still operates on the foundational assumption that one parent must be the primary, and the other must be the secondary. The weight of this history is why so many divorced dads in 2026 feel a sense of identity crisis. They are being told to be equal parents by a society that still uses a legal framework built in 1885. They are expected to be emotionally vulnerable and present, yet they are often still judged by their ability to provide financial support above all else. This tension is not an accident. It is the result of a century of redefining the family as an emotional convenience for the state, rather than a stable, multi-generational unit. We have analyzed how the law moved from property to sentiment, and how that sentiment was used to exclude men from the daily lives of their children. We have seen how the Industrial Revolution physically removed fathers from the home, providing the legal excuse to remove them from the custody agreement. But there is a deeper layer to this. There is a specific mechanism that was introduced in the late 20th century that changed the stakes of divorce forever. It wasn't just about who got the kids. It was about how the state became a permanent third party in the relationship between a father and his children. If you think the shift from property to sentiment was the biggest change, you are only seeing half the picture. The real transformation happened when the family was redefined as an administrative unit of the government. In the next part, we are going to look at the massive expansion of the Title 4D program and how the financialization of fatherhood turned the abstract family into a federal balance sheet. We will look at why your state has a vested financial interest in the way your custody agreement is written, and how a 1975 law changed the trajectory of your life before you were even born. The rabbit hole goes much deeper than just a judge's discretion. Prepare for the financial autopsy of the American fatherhood. To understand the modern reality of the American father, we have to talk about 1975. Before this year, if you were a divorced dad, your financial relationship with your children was largely a private matter or a civil dispute between you and your ex-spouse. But in 1975, the United States government fundamentally altered the DNA of the American family by passing Title 4D of the Social Security Act. This wasn't just a minor administrative update. It was the birth of the state as the permanent third party in your household. Imagine a man named David in 1978. David is a machinist in Ohio, recently divorced. Under the new Title 4D regulations, for the first time in history, the government established a massive federal and state infrastructure designed specifically to track, monitor, and collect money from what they labeled the non-custodial parent. The primary motivation wasn't family bonding or child well-being. It was fiscal recovery. The federal government was seeing a massive spike in spending on the Aid to Families with Dependent Children program, now known as TANF. To lower the welfare bill, the government decided that the state should act as a collection agency. If a mother received state aid, the state would now step into her shoes and sue the father to pay them back. This turned the abstract concept of fatherhood into a ledger entry for the state's budget. This created a historical trend where the father's role was increasingly defined by his status as a debtor. By 1984 and 1988, with the Child Support Enforcement Amendments and the Family Support Act, the system became even more rigid. The federal government mandated that all states create mathematical formulas for child support. Before this, a judge might look at David's specific life, his rent, his tools, his ability to actually see his kids, and make a human decision. After these acts, judicial discretion was largely replaced by the presumptive guideline. These formulas, like the income shares model or the percentage of income model, were designed to ensure a specific standard of living in the custodial house, often without a deep analysis of the father's ability to maintain a home where the children could actually stay. Let's look at the data on how this financialization changed the landscape. Under Title 4D, states began receiving federal incentive payments based on the amount of child support they collected. This created a powerful bureaucratic incentive. The more money a state moved from non-custodial parents to custodial parents or back into the state coffers, the more federal funding that state's child support agency received. For a father in the 1990s, this meant the system was no longer neutral. It became a high-efficiency machine designed to keep the non-custodial parent in a specific financial category. Imagine if you were a business owner and the government told you that your partner now had the right to 50% of your revenue, but you had zero right to enter the office or see the books. That is the structural reality many fathers began to face. The legal system effectively decoupled the right to parent from the obligation to pay. In most jurisdictions, child support and visitation are treated as two entirely separate legal silos. If a father is denied his time with his children, he is told he must still pay his support in full, and that his only recourse is to file an expensive separate legal action. However, if he fails to pay his support, the state's enforcement mechanisms, ranging from driver's license suspensions to professional license revocations and even incarceration, trigger automatically. This created an asymmetrical power dynamic where the state's role is to enforce the father's financial duties, while often remaining passive about his parental rights. By the time we reach 2026, this system has become almost entirely digitized and automated. Imagine a father today named Marcus. Marcus works as a software contractor. When his contract ends and his income drops, the Title 4D system doesn't automatically adjust. It continues to bill him at his peak earning rate. In many states, the process to modify a support order is so complex and slow that by the time a hearing is granted, Marcus is already thousands of dollars in arrears. These arrears often carry high interest rates, sometimes exceeding 12%. Marcus isn't just a dad anymore. He is a permanent debtor to the state system. The case studies of the 2000s and 2010s show the devastating effect of this financialization. When a father falls behind due to job loss or illness, the system's primary response is to strip away his tools for recovery. Suspending a driver's license for a man who needs to drive to work is a historical anomaly that lacks traditional logical consistency, yet it became a standard enforcement tool. The abstract family was no longer about the emotional health of the child, it was about the administrative efficiency of the Title IV agency. This leads to what sociologists call the deadbeat dad narrative. This narrative was heavily promoted in the 1990s as a way to justify these aggressive state interventions. By painting the father as a flight risk or a financial parasite, the state could justify seizing bank accounts and garnishing wages without the traditional due process protections afforded in other civil matters. However, data from the U.S. Census Bureau has consistently shown that the vast majority of fathers who do not pay their full support are not unwilling, but unable. They are often low-income men who are overwhelmed by a system that calculates their obligations based on potential income rather than actual income. The step-by-step evolution of this system has led us to a 2026 reality where the family unit is often treated as a primary household and a secondary satellite. The satellite parent, the father, is expected to provide the fuel for the primary household while remaining in a stable, distant orbit. This financial architecture is the silent wall that keeps the abstract concept of family from becoming a lived reality for millions of men. Even if a father is deeply involved, the constant threat of state enforcement actions creates a background of chronic stress that colors the entire parenting experience. We have to ask, what does this do to the children? When the state defines the father primarily as a source of revenue, that message trickles down. It affects how the custodial parent views the father, how the community views the father, and eventually how the children view their own heritage. The family is no longer a circle. It is a line of distribution. But the financialization of fatherhood is only one part of the transformation. While the state was busy turning dads into debtors, another shift was happening in the world of social science and psychology. A new set of theories was being developed to explain why fathers were less important than we once thought. This wasn't just about money, it was about the very soul of the father-child bond. If you thought the legal and financial hurdles were the only thing standing in your way, you haven't seen the psychological war that was waged on the concept of paternal necessity. In the next part, we are going to dive into the rise of the secondary parent theory. We will look at how the educational and psychological elite in the United States spent 40 years devaluing the specific, unique contributions of fathers to child development. We will analyze the data that proves them wrong and look at how this academic bias filtered down into the courtrooms, creating the mother-first default that still dominates today. The battle for your identity as a dad isn't just in the bank, it is in the mind. We are going to look at the psychological autopsy of the American fatherhood. To understand why the modern court system treats the American father as a secondary character, we have to look at the psychological coup that occurred in the 1970s and 80s. While the financial structures of Title IV were turning dads into debtors, a group of influential scholars was busy redefining what it meant to be a parent in the first place. This was the era of the primary caregiver rule, and it is the reason why, even in 2026, many fathers feel like they are fighting a ghost in the courtroom. Imagine a man named Brian in 1982. Brian is a dedicated architect in Chicago. He is a hands-on father who spends every evening playing with his two daughters, reading them stories, and taking them to the park on weekends. But when Brian and his wife decide to divorce, he enters a legal system that has just been handed a new psychological Bible. That Bible was a book titled Beyond the Best Interests of the Child, written by Joseph Goldstein, Anna Freud, and Albert Solnit. This single text did more to marginalize divorced fathers than almost any other piece of literature in the 20th century. The authors introduced the concept of the psychological parent. Their theory was simple but devastating. They argued that a child's healthy development depends almost entirely on an unbroken, continuous relationship with one primary parent. They suggested that any shared custody arrangement that forced the child to move between two homes was inherently disruptive and psychologically harmful. In their view, the court's job was to pick a winner and a loser. One parent would be the psychological parent, and the other would be a visitor. Because of the social norms of the 1980s, the psychological parent was almost always defined as the person who performed the day-to-day domestic tasks, the feeding, the bathing, and the laundry. This was the birth of the primary caregiver rule. It shifted the focus from the father's historical legal rights and his biological importance to a checklist of domestic chores. If Brian worked 45 hours a week to pay the mortgage while his wife stayed home, the court used his very provision for the family as evidence that he was not the psychological parent. By being a successful provider, Brian was inadvertently proving that he was a secondary parent. The court saw his absence during work hours as a lack of bond, rather than a sacrifice for the family's stability. Step by step, the psychological community began to weaponize attachment theory. Originally developed by John Bowlby and Mary Ainsworth, attachment theory was meant to describe the critical bond between infants and their caregivers. However, in the hands of family court evaluators in the 90s and early 2000s, it was twisted into a justification for limited visitation. They argued that if a father hadn't been the one to soothe a crying infant at 3 a.m. every single night, he had failed to form a secure attachment. This led to the creation of restrictive visitation schedules that gave fathers only a few hours of time during the day, often with no overnights for years. The logic was that a child would suffer a traumatic rupture if they slept in a different house than their primary caregiver. For fathers like Brian, this created a catch-22. To build a bond, he needed time. But to get time, the court required him to already have a bond that met their specific, narrow domestic criteria. This historical trend effectively categorized fatherhood as an optional luxury, a secondary layer of play and fun that was nice to have but not essential for a child's survival or success. Now, fast forward to 2026 and imagine a father named Christopher. Christopher lives in a world where we have more data than ever before on the importance of fathers. We have thousands of case studies showing that children with active 50-50 fathers have better educational outcomes, lower rates of substance abuse, and higher emotional intelligence. Yet, Christopher still finds himself trapped in the residual effects of the psychological parent theory. In the modern courtroom, this often manifests as maternal gatekeeping. Maternal gatekeeping is a psychological phenomenon where one parent, historically the mother, controls the other parent's access to the children based on her own assessment of his competence. In 2026, even though the law might say joint custody is the goal, the abstract concept of family still grants the mother the role of the primary administrator. If Christopher wants to take the kids for an extra weekend, he doesn't just check the schedule. He often has to navigate a gauntlet of emotional approval. The system still defaults to the idea that the mother is the manager of the child's life, and the father is a subcontractor. The data reveals a stark reality. When a father is labeled a visitor, his involvement drops precipitously over time. This isn't because he doesn't care. It's because of a psychological process called role disposability. When the state, the school system, and the medical establishment all treat the father as a secondary contact, the father begins to internalize the idea that he is not essential. He becomes a peripheral figure in his own story. This is the psychological autopsy of the American fatherhood. The system didn't just take his time, it attempted to take his identity. Imagine if you were told that you were an equal partner in a business, but you were never allowed to see the bank statements, you weren't allowed to talk to the clients, and your partner had the right to veto every decision you made. You wouldn't feel like a partner, you would feel like an employee. This is how millions of divorced dads feel in 2026. They are expected to have the passion of a parent, but are given the authority of a babysitter. The impact of this devaluing of the father is seen in the rise of what researchers call the parent-child bond erosion. When the court limits a father to 4 days a month, it is effectively engineering a decline in that relationship. It is impossible to maintain the same level of intimacy and influence in 4 days that a parent has in 26. Historically, this was framed as the best interest of the child to maintain stability. But by 2026, the potential outcomes of this stability have been revealed to be a form of state-sanctioned fatherlessness. We have explored the legal shift from property to sentiment. We have looked at the financialization of the father as a debtor. And now we have seen how the psychological community provided the intellectual cover for these changes by labeling fathers as non-essential. But there is a final piece to this puzzle, a mechanism that is often used as the ultimate trump card in custody disputes. It is the piece that can override history, data, and even the best financial standing. If the psychological parent theory is the scalpel used to limit a father's role, this next mechanism is the sledgehammer. It is the most sensitive and high-stakes area of family law, and it is where the abstract concept of family meets the raw power of the state. In Part 5, we are going to analyze the rise of the tactical restraining order and the domestic violence narrative in family court. We will look at how a 1994 federal law intended to protect victims became, in some case studies, a strategic tool for obtaining exclusive custody. We will examine the data on false allegations and the permanent shadow they cast on a father's legal standing. The narrative is about to get much darker, and the stakes for the American father have never been higher. Reach for your notes, we are diving into the legal battlefield of the protective order. The concept of the silver bullet is not a conspiracy theory born in the corners of the internet. It is a term used by family law attorneys behind closed doors to describe the tactical use of a domestic violence restraining order to gain an immediate and nearly insurmountable advantage in a custody battle. To understand how we reached this point in 2026, we have to trace the legal evolution of the protective order and how the definition of family shifted from a private, autonomous unit to a state-regulated safety zone where allegations are often treated as settled facts before a single witness is called to the stand. Imagine a father named James in the year 2026. James is a middle manager at a logistics firm in Virginia. He has no criminal record, no history of substance abuse, and has been a present active father to his 7-year-old son. One Tuesday afternoon, while James is in a meeting, 2 sheriff's deputies arrive at his office. They serve him with an ex parte temporary restraining order. In an instant, the abstract concept of family that James has lived in for a decade is liquidated. He is ordered to vacate his home immediately. He is barred from contacting his wife. Most devastatingly, he is prohibited from seeing or even calling his son. This happened without James being present in court, without his knowledge that a hearing was taking place, and without a single shred of physical evidence or police reports. This is the power of the ex parte order, a legal mechanism that allows a judge to grant a request based solely on the testimony or affidavit of one party. Historically, these were intended for emergency situations where there was an immediate threat of physical harm. However, the historical trends from 1994 to 2026 show that the definition of what constitutes a threat has expanded significantly. This expansion began in earnest with the passage of the Violence Against Women Act in 1994. While the act was designed with the noble and necessary goal of protecting victims of genuine abuse, it also created a massive federal funding apparatus that incentivized states to increase the number of protective orders issued. In the 1990s and early 2000s, many states moved toward a preponderance of the evidence standard for civil restraining orders. In a criminal court, you are innocent until proven guilty beyond a reasonable doubt. In a family court matter regarding a restraining order, the standard is much lower. It essentially means that if a judge believes there is a 51% chance that an allegation is true, or even just that the person filing feels threatened, the order can be granted. By 2026, this has evolved into what some legal scholars call the doctrine of emotional safety. James finds himself in a position where he is not accused of hitting anyone, but of creating a hostile environment. Because family court is a court of equity, not a court of law, judges often lean toward a better safe than sorry approach. If they deny an order and something happens, it is a front-page scandal. If they grant a potentially false order, the only victim is the father's relationship with his child, which the system has already been conditioned to view as secondary. Step by step, the tactical restraining order functions as a master key for custody. Once James is removed from the home, a new status quo is established. As we discussed in Part 4, the legal system prizes stability. If James is barred from the home for 90 days while waiting for a full hearing, the court eventually looks at the situation and sees that the child has been living exclusively with the mother for 3 months. Even if the restraining order is eventually dismissed for lack of evidence, the damage is done. The mother is now the primary caregiver by default. The psychological parent theory is triggered. The father has been successfully converted from a parent into a litigant. The data on this is stark. Case studies from various state bar associations have noted that a significant percentage of restraining orders filed during a pending divorce are eventually dismissed or found to be without merit. Yet, the legal consequences during the waiting period are permanent. In 2026, these orders are often integrated with smartphone technology. James might have a geofencing app installed on his phone by court order that alerts the police if he accidentally drives within 500 feet of his former home or his son's school. The abstract family is now a digital prison. For the divorced dad in U.S. history, this represents the ultimate loss of agency. In the 1800s, a father could only lose his children for gross moral turpitude or criminal abandonment. Today, the mere utterance of the word fear in a civil affidavit can result in the immediate suspension of parental rights. This shift reflects a broader social movement that has redefined the family as a high-risk environment that requires constant state oversight. The father is no longer the protector of the family. He is frequently portrayed as the person the family needs protection from. We must analyze the potential outcomes of this environment. When a father like James is subjected to a tactical restraining order, The psychological impact is often a form of secondary trauma. He is forced into a defensive crouch, spending his life savings on legal fees to prove a negative, that he is not a threat. This financial drain is not accidental. In high-conflict divorce cases, the restraining order is often used to deplete the other party's resources, making it impossible for them to fight for 50-50 custody in the long run. Furthermore, the impact on the child is often overlooked in the quest for legal safety. When a child sees their father suddenly vanished by the state, without explanation, it creates a deep-seated sense of instability and confusion. The state, in its attempt to provide safety, often ends up inflicting a different kind of harm: the forced severance of a healthy paternal bond. By 2026, the use of parental alienation tactics often coincides with these legal maneuvers. The father is not just physically absent. He is characterized to the child as someone dangerous or unstable. This brings us to a critical realization. The abstract concept of family for the divorced dad has been weaponized. The very laws meant to ensure domestic peace have been adapted into tools for domestic warfare. The historical trend is moving toward a system where parentage is a revocable license, rather than an inherent right. If you can be removed from your child's life on a Tuesday afternoon based on a single unverified document, you do not have rights. You have permissions. We have now analyzed the legal shift from property to sentiment, the financialization of the father as a debtor, the psychological devaluing of the paternal bond, and the tactical weaponization of the protective order. All of these factors converge to create a multi-billion-dollar industry. Divorce in America is not just a social event. It is a massive economic engine. The lawyers, the court-appointed evaluators, the therapists, and the state agencies all have a seat at the table where your family is being carved up. In Part 6, we are going to look at the divorce industry itself. We will examine the billable hour, and why the current legal structure is designed to maximize conflict, rather than resolve it. We will look at how the 2026 legal market treats your children as the inventory that keeps the machine running. If you want to know why it feels like the system is working against you, it is because you need to follow the money. We are going to conduct a financial audit of the American divorce machine. The machinery of the American legal system does not run on justice. It runs on conflict. When we talk about the abstract concept of family for divorced dads in 2026, we are not just talking about social dynamics. We are talking about a $50 billion a year industry that views your domestic tragedy as its primary fuel source. To understand your position as a father in U.S. history, you must understand that you have been moved from the head of a household to the line item on a profit and loss statement. This is the financial audit of the American divorce machine. Imagine a man named Jordan in 2026. Jordan is a senior project manager in Denver, earning a respectable salary. He and his spouse have decided to end their marriage. Jordan wants equal time with his 2 children. He assumes that in a modern, enlightened society, this would be a simple administrative checkoff. He is wrong. The moment Jordan enters the legal arena, he is no longer a father. He is a litigant in a high-stakes game of attrition. The first step in this machine is the billable hour model. This is a historical trend that has remained largely unchanged for a century. In almost every other sector of the economy, efficiency is rewarded. In the divorce industry, the incentive structure is inverted. If Jordan and his ex-wife sit down in a room and agree to a 50-50th split in one afternoon, the lawyers make perhaps $3,000. However, if the lawyers can identify a point of friction, perhaps a dispute over which preschool the children should attend or who gets the children on the third Monday of October, that $3,000 can easily transform into $30,000 or $300,000. This leads to the discovery phase, the most expensive and invasive part of the process. In 2026, this involves more than just bank statements. It involves the forensic auditing of Jordan's entire digital life. Lawyers will demand 5 years of text messages, social media posts, and location data. Every late-night vent to a friend or every missed FaceTime call is scrutinized for its potential to be framed as evidence of parental unfitness. Step by step, the machine deconstructs Jordan's humanity and reassembles it into a series of exhibits. The goal here isn't truth. It is leverage. For the divorced dad, the abstract concept of family is slowly replaced by a stack of 3-ring binders. But the lawyers are only the front line. The modern divorce machine has birthed an entire ecosystem of auxiliary experts. In Jordan's case, because there is a disagreement over the custody schedule, the court appoints a custody evaluator. This is usually a psychologist who charges between $10,000 and $20,000 to perform a social study. Jordan is then told he must also pay for a guardian ad litem or a GAL. Historically, the GAL was meant to be the voice of the child. In practice, in 2026, the GAL is often another attorney whose fees are split between the parents but who operates with nearly total judicial immunity. Jordan now finds himself in a scenario where he is paying 3 or 4 different professionals to debate his worth as a parent. These experts use the psychological parent theory we discussed in Part 4 to justify their fees. They conduct home visits, administer personality tests like the MMPI-2, and interview teachers. Each of these steps is a billable event. Data from the American Academy of Matrimonial Lawyers suggests that the cost of these experts has outpaced inflation by nearly double over the last 2 decades. The system has redefined the family as an administrative unit that requires professional management. Let's look at the trial math. Imagine if the dispute is over a $500 a month difference in child support. Over 10 years, that represents $60,000. If Jordan spends $70,000 in legal fees to win that dispute, he has effectively lost $10,000 in years of his life. The industry knows this. They understand that for a father, the fight isn't about the $500. It is about the principle of being an equal presence in his child's life. The machine weaponizes a father's love for his children, using it as a psychological hook to keep the litigation moving. In 2026, we see the rise of the parenting coordinator, a role that didn't exist in the historical landscape of the 19th century. A parenting coordinator is a quasi-judicial officer who handles day-to-day disputes like whether a child can go to a sleepover. They charge $300 an hour. Jordan is now in a position where he cannot make a basic parenting decision without a billable interaction. This is the ultimate abstraction of the family. The natural, organic authority of the father has been outsourced to a third-party contractor. The historical trends show that the divorce industry thrives on the status quo bias. If a court issues a temporary order giving Jordan every other weekend, the machine has a vested interest in keeping that order in place for as long as possible. Why? Because the more Jordan fights to change it, the more revenue the machine generates. If he accepts the secondary role, the revenue stops. Therefore, the system is designed to be slow, cumbersome, and prone to delays. Every continuance, every rescheduled hearing, and every unanswered motion is a victory for the machine's bottom line. Consider the financialization of the children themselves. In the eyes of the state and the industry, the child is the inventory that justifies the existence of the infrastructure. Title 4D funding, which we analyzed in Part 3, provides the state with federal kickbacks for every dollar of child support collected. This creates a scenario where the state itself is a stakeholder in ensuring that one parent remains a payer and the other remains a payee. If 50-50 custody becomes the default, which it is trending toward in some states in 2026, the amount of child support transferred often drops. This threatens the federal funding levels for state agencies. Thus, there is a systemic financial resistance to the very equality that fathers are fighting for. Jordan's case study is not an outlier. It is the blueprint. By the time his case reaches a final decree, he may have liquidated his 401k, taken out a second mortgage, or borrowed money from his own aging parents. He has been financially bled white, not by his children, but by a system that claims to be protecting them. The abstract concept of family for Jordan has become a ghost of what it once was. A memory of a home that was traded for a pile of legal invoices. We have to ask, what is the cultural byproduct of this machine? When a society treats its fathers as ATMs and its children as billable units, the very fabric of the community begins to fray. The machine doesn't just take Jordan's money, it takes his spirit. It leaves him cynical, exhausted, and often disconnected from the children he fought so hard to stay near. This is the silent toll of the American divorce machine, the destruction of the paternal heart in the name of administrative efficiency. But there is another force at play. It isn't just the money or the law. There is a cultural narrative that supports this machine, a story we have been telling ourselves for 50 years about what a dad is. We see it in movies, in commercials, and on social media. It is the trope of the incompetent dad. This narrative provides the social permission for the machine to operate the way it does. If the public believes that fathers are naturally less capable, then the machine's bias seems justified. In Part 7, we are going to dive into the media deconstruction of fatherhood. We will look at how the shift from the wise father figures of the 1950s to the secondary dads of the 1990s and 2000s directly influenced the way judges and juries view men in 2026. We will analyze the data on media representation and how it mirrors the decline of paternal rights in the courtroom. The screen in your living room has been training you to accept your own marginalization for decades. It is time to look behind the lens. To understand why the modern court system views you as a visitor, we have to look at the screen in your living room. Culture precedes law. Before a judge ever signs an order, their worldview has been shaped by decades of media consumption. In the context of American history, the portrayal of fathers has undergone a deliberate and systematic deconstruction. If you were a father in 1950, you were portrayed as the moral North Star. Think Jim Anderson in Father Knows Best. By the 1990s, you were Homer Simpson. By 2026, the trope has evolved into something even more insidious: the dangerous or irrelevant secondary character. Imagine a man named Ethan in 2026. Ethan is a highly skilled pediatric nurse. He understands child development, nutrition, and medical care better than the average person. However, Ethan is currently in the middle of a high-conflict divorce. When he walks into the courtroom, he is not seen as a medical professional or a devoted caregiver. He is filtered through the lens of the bumbling dad. This archetype, which has been the bread and butter of American sitcoms and commercials for 40 years, suggests that men are domestically incompetent. The historical trends show that as women moved into the workforce, a positive social development, the media did not respond by showing men becoming equally competent at home. Instead, it doubled down on the idea that men are lost without a woman to guide them. This creates a psychological phenomenon in the legal system known as cognitive ease. When a judge or a child custody evaluator sees Ethan, it is mentally easier for them to fit him into the pre-existing script of the fun weekend dad, who probably forgets the children's allergies and lets them stay up too late. This is the media-driven default. Step by step, the media has stripped the father of his domestic authority. In the 1980s, we saw the rise of the deadbeat dad narrative in news media, which focused on the small percentage of men who abandoned their obligations and projected that image onto the entire population of divorced fathers. By the 2000s, advertising shifted toward the gatekeeper model. In this model, advertisers realized that women make the majority of household purchasing decisions. To appeal to this demographic, commercials began portraying fathers as an extra child that the mother has to manage. Think of the classic detergent or paper towel commercial where the dad makes a massive mess and the mom rolls her eyes, cleans it up, and restores order. This isn't just a harmless joke. It is a constant, repetitive reinforcement of the idea that the father is not an equal stakeholder in the home. For a man like Ethan in 2026, this media environment means he is fighting an uphill battle against a stereotype that says he is a secondary parent by biological nature. Let's look at the data regarding media representation. A major study of over 2,000 domestic advertisements found that men were depicted in caregiving roles less than 10% of the time. When they were shown with children, it was almost always in a play-based or outdoor context. They were rarely shown performing visible labor of parenting, scheduling doctor appointments, managing school forms, or emotional regulation. This historical trend has direct potential outcomes in the courtroom. When a judge has to decide who gets the tie-breaking vote on educational or medical decisions, the media-trained brain defaults to the mother as the COO of the family. In 2026, this has been further complicated by the rise of short-form social media content. We see the emergence of dad-shaming in digital spaces. Imagine if Ethan posts a photo of his children eating pizza on a Friday night. On social media, this can be weaponized by the opposing party to show a lack of nutritional oversight. However, if the mother posts the same photo, it is framed as a fun treat or a relatable parenting moment. This double standard is rooted in the historical transition of the father from the head of the household to the guest of the household. The media deconstruction of fatherhood also involves the erasure of paternal grief. In U.S. history, the image of the grieving father is almost non-existent. We are taught that men are stoic, that they move on quickly, and that their primary concern is their financial bottom line. This narrative serves the divorce machine we discussed in Part 6. If society believes that men don't feel the deep, soul-crushing pain of losing daily access to their children, then the system doesn't have to feel guilty about marginalizing them. The media has effectively anesthetized the public to the trauma of paternal displacement. Case studies of high-conflict divorces in the 2020s show that legal teams now actively use media tropes as part of their strategy. They will attempt to provoke a father into a moment of anger, which is a natural human response to being separated from one's children, and then frame that anger as evidence of an unstable personality. This plays directly into the angry man trope that is ubiquitous in modern film and television. The father is trapped. If he is stoic, he is seen as disconnected and cold. If he is emotional, he is seen as dangerous. This is a narrow corridor of acceptable behavior that doesn't exist for the other parent. Consider the historical impact of films like Kramer vs. Kramer in 1979. While it was groundbreaking for showing a father's capacity to care for a child, the ultimate resolution still suggested that the mother's bond was the primary one. By the time we reached the 2010s, films like Marriage Story continued this trend by focusing on the systemic exhaustion of the process, yet often leaving the father in a position where he has to move his entire life just to maintain a fraction of his previous involvement. The abstract concept of family in these stories is almost always one of maternal centrality. For Ethan in 2026, the challenge is to write a new script. But how do you fight a narrative that is backed by billions of dollars in advertising and decades of cultural momentum? The media tells us that the father is the satellite and the court follows that orbit. We are seeing a historical anomaly where the biological and social importance of the father is higher than ever in scientific literature, yet lower than ever in cultural prestige. This disconnect is where the divorced dad lives. He is told by experts that he is essential, but told by his TV, his social media feed, and his judge that he is optional. This cultural programming is the final layer of the wall. It is what makes the financialization, the psychological marginalization, and the legal hurdles feel normal. It is the reason why, when you tell someone you only see your kids every other weekend, they don't gasp in horror. They ask what you're doing with your free time. The normalization of paternal absence is the media's greatest achievement in the last half-century. But the tide is starting to turn. There is a movement growing in the shadows of this deconstruction. As the data on the fatherless crisis becomes impossible to ignore, a new wave of historical actors is stepping onto the stage. They are not asking for permission to be parents. They are demanding a fundamental rewrite of the American legal code. In Part 8, we are going to analyze the rise of the father's rights movement and the legislative battle for the 50-50 presumption. We will look at why some states are leading the charge for equal parenting and why others are fighting it with everything they have. The battle for the abstract family is moving from the screen to the State House. Get ready for the political autopsy of the American fatherhood. The transition from the cultural deconstruction of the father to the political mobilization of the father began as a quiet murmur in the 1980s and has exploded into a full-scale legislative war by 2026. For decades, the abstract concept of family was something that happened to men. Now men are attempting to reclaim the definition of family through the State House. This is the era of the legislative presumption, and it represents the most significant challenge to the judicial discretion model that has dominated the United States for over a century. To understand why your local courtroom operates the way it does, we have to look at the lobbying groups, the peer-reviewed data, and the specific bills that are currently redrawing the map of the American household. Imagine a man named Anthony in the year 2026. Anthony lives in Kentucky. In 2018, Kentucky became a pioneer by passing a law that established a rebuttable presumption that joint custody and equal parenting time are in the best interests of the child. For Anthony, this changed everything. Before this law, the historical trend in Kentucky, as in most states, was for one parent to be granted the role of primary residential custodian, while the other was granted visitation. The burden of proof was on the father to show why he deserved more time. Under the new 50-50 law, the starting line moved. Now, the burden of proof is on the person who wants to limit the other parent's time. They must provide clear and convincing evidence that equal time would be harmful to the child. This shift from a neutral starting line to a pro-equality starting line is the central battlefield of the fatherhood movement. By 2026, we have seen a wave of similar legislation across the country, with states like Florida, West Virginia, and Arizona passing variations of the equal parenting presumption. But why did it take so long? And why is there still such fierce resistance in states like California, New York, and Massachusetts? To answer this, we have to look at the step-by-step process of how these bills are either passed or killed in committee. The primary driver for these legislative changes has been the massive accumulation of social science data. In the last 40 years, researchers like Dr. Linda Nielsen have analyzed over 60 peer-reviewed studies comparing children in joint physical custody to those in sole maternal custody. The data is overwhelming. Children in shared parenting arrangements show better outcomes in nearly every category, including emotional health, academic performance, and lower rates of teenage pregnancy and substance abuse. This data became the ammunition for the fathers' rights movement. They stopped arguing based on their own rights and started arguing based on the child's rights to have two parents. However, every time a 50-50 bill is introduced, a powerful coalition of interest groups emerges to oppose it. The most consistent opponent is often the State Bar Association. This is where we follow the money. As we analyzed in Part 6, the divorce industry is a multi-billion-dollar machine that thrives on conflict. If 50-50 custody becomes the law of the land, the incentive to litigate drops significantly. If both parents know they are going to get equal time regardless of how much they spend on lawyers, they are more likely to settle their cases quickly and move on. For the legal industry, an equal parenting presumption is a direct threat to the billable hour. The historical trends show that these bar associations often lobby against these bills by using the safety narrative we discussed in Part 5. They argue that a mandatory presumption of 50-50 custody would endanger victims of domestic violence by forcing them into close contact with their abusers. While the bills almost always include carve-outs for proven cases of abuse, the opposition uses the high-stakes fear of a hypothetical tragedy to scare legislators. This has created a political stalemate in many states where the abstract concept of family is held hostage by the financial interests of the legal guild. Another layer of resistance comes from the administrative state. In 2026, the Title IV funding mechanisms we explored in Part 3 remain a major factor. If a state moves to a 50-50 default, child support payments often decrease or are eliminated entirely in cases where both parents have similar incomes. This can lead to a reduction in federal incentive payments to the state's child support enforcement agency. Consequently, the very bureaucrats who manage the family court system often provide testimony to legislators suggesting that these bills would create administrative chaos or lead to a rise in child poverty. They are effectively protecting their own budget at the expense of the paternal bond. Now, imagine Anthony again, but this time imagine he lives in a state that has rejected the 50-50 presumption. In this scenario, Anthony is subject to the total discretion of a single judge. This is what legal scholars call the Wild West of family law. Without a legislative presumption, a judge can decide Anthony's fate based on their own personal biases, their mood that day, or their outdated belief in the tender years doctrine. The potential outcomes for Anthony in this state are completely unpredictable. He might get 50-50 or he might get 4 days a month. This lack of consistency is what drives the high-conflict litigation that fuels the machine. The political autopsy of the American fatherhood reveals a deep divide. On one side, you have a growing movement of parents and social scientists pushing for a standardized pro-equality framework. On the other, you have a well-funded infrastructure of lawyers and state agencies fighting to maintain the discretionary model. In 2026, this has led to a geographic lottery. Your rights as a father are often determined not by your character or your involvement, but by which side of a state line you happen to reside on. Step by step, the fathers' rights movement has had to become more sophisticated. They have moved past the era of protesting on bridges in superhero costumes and into the era of data-driven lobbying and strategic litigation. They are challenging the constitutionality of the best interests of the child standard itself, arguing that a parent's right to raise their child is a fundamental liberty interest protected by the 14th Amendment. They are forcing the courts to treat the removal of a child from a parent as a matter of strict scrutiny, the highest level of judicial review. The impact of these political battles is starting to show in the data. In states that have passed 50-50 laws, we are seeing a historical trend toward lower divorce rates and a decrease in high-conflict custody filings. When the system removes the prize of primary custody, it removes the incentive to fight for it. The abstract concept of family is beginning to shift back toward a model of cooperation and shared responsibility, at least in the states that have embraced the change. But even in the states with the best laws, there is a final hurdle. A law on the books is only as good as the person wearing the robe. The political battle has moved from the State House to the judicial appointment process. Who are these judges? How are they trained? And why do so many of them continue to ignore the very laws they are sworn to uphold? In Part 9, we are going to look at the judicial autocracy. We will analyze the training manuals given to family court judges and the systemic bias that persists even in the face of legislative change. We will look at the case studies of judges who have been removed for bias and why the accountability for the bench is the final frontier of the fatherhood movement. The gavel is about to fall. Stay tuned for the analysis of the judicial gatekeepers. The weight of a gavel is not just in its wood, but in the near-absolute immunity of the person wielding it. When we talk about the judicial gatekeepers in 2026, we are discussing a level of power that is almost unique in the American legal system. In most areas of law, from contract disputes to criminal trials, There are rigid rules of evidence and clear-cut statutes that constrain a judge's decisions. But in family court, the abstract concept of family is filtered through a legal loophole large enough to drive a truck through. That loophole is called judicial discretion. It is the ability of a single individual to make life-altering decisions based on their own subjective interpretation of the best interests of the child. Imagine a father named Daniel in 2026. Daniel is a veteran firefighter in a mid-sized city in Texas. He has a clean record, a stable home, and a deep active bond with his 6-year-old daughter. Texas has made strides in encouraging expanded standard possession, but Daniel is seeking a true 50-50 split. He enters the courtroom of a judge who has been on the bench since 1998. This judge, let's call him Judge Miller, grew up in a legal culture that viewed fathers as providers and mothers as nurturers. Despite the newer statutes designed to encourage equal time, Judge Miller still possesses the power of the robe. During the hearing, Daniel presents his work schedule. As a firefighter, he works 24 hours on and 48 hours off. Under any logical analysis of parenting quality, this gives Daniel a massive amount of weekday time to be present for school runs, homework, and doctor visits. However, Judge Miller uses his discretion to decide that the child needs a primary residence for school stability. He views Daniel's rotating schedule not as an opportunity for more father-child time, but as a disruption to the child's routine. With one stroke of a pen, Miller overrides the legislative intent of the state and relegates Daniel to a visitor role. This is the judicial autocracy in action. It is a system where the law says one thing, but the gatekeeper's personal philosophy says another. To understand why this happens, we must look at the historical trends in judicial training. Judges are not just born. They are molded by bench books and judicial seminars. These bench books are internal manuals that provide guidelines for everything from sentencing to custody. For decades, these manuals have been heavily influenced by the psychological parent theory we analyzed in Part 4. Even in 2026, many of these internal training documents haven't caught up to the latest longitudinal data on shared parenting. They often emphasize a primary-secondary parent model because it is easier to manage administratively. It is a path of least resistance. If a judge picks a primary parent, there is less conflict to manage in the future than if they have to mediate between two equal parents. Furthermore, we have to analyze the systemic bias inherent in the judicial appointment and election process. In the United States, many family court judges are either appointed by political figures or elected in low-turnout local races. Historically, the pipeline to the family court bench often comes from the ranks of child advocates, prosecutors, or social workers. While these are noble professions, they often come with a professional bias that views the family through the lens of pathology or risk management. When your entire career has been spent dealing with families in crisis, you begin to see every family as a potential crisis. For a father like Daniel, this means he is viewed through a lens of suspicion rather than a lens of partnership. The data on judicial accountability is perhaps the most sobering part of this masterclass. In the U.S. legal system, you can appeal a judge's decision, but the standard for overturning a family court ruling is incredibly high. It is called the abuse of discretion standard. To win an appeal, a father must prove not just that the judge was wrong, but that the judge's decision was so arbitrary and unreasonable that it shocks the conscience. In practice, this happens in less than 5% of cases. For most divorced dads, the trial judge is the supreme court of their lives. There is no real oversight for a judge who simply prefers the mother's lifestyle or the father's income over his presence. Step by step, the judicial gatekeeper maintains the status quo through the use of in-chambers meetings and off-the-record discussions. In 2026, much of the real work of a custody case happens behind closed doors, where the lawyers and the judge negotiate the terms of a father's life. The father himself is often not even in the room for these critical moments. The judge might tell the lawyers that he doesn't like 50-50 for children under the age of 10. The lawyers, knowing they have to appear before this same judge every week, will often advise their clients to settle for less time rather than risk the judge's wrath in a full trial. This creates a shadow legal system where the written law of the state is secondary to the unwritten rules of the local courthouse. Case studies of judicial removal are rare, and when they do occur, it is usually for financial corruption or gross criminal misconduct, not for systemic bias against fathers. This creates a culture of judicial entitlement. When a judge knows they cannot be fired or overruled for their custody decisions, they have no incentive to evolve their thinking. They become the final roadblock to the abstract concept of family being realized as a dual-parent reality. Imagine if your boss could cut your salary by 70%, take away your house and limit your access to your children, all while claiming it was for your own best interest, and you had almost no way to challenge it. That is the structural reality of the family court bench. The robe provides a shield that protects the judge from the consequences of their own biases. For the American father, the courthouse is not always a place of justice. It is often a place of management, where his role is managed down to fit the judge's personal comfort level. We have now analyzed every layer of the wall. We have seen the legal history, the financial incentives, the psychological devaluing, the tactical weaponization of allegations, the media's mockery, the legislative battles, and finally the judicial gatekeepers who hold the keys. Can feel like an impossible landscape, but this is a masterclass in history and analysis, and history is never static. The weight of the data is reaching a breaking point. The social costs of fatherless homes are becoming too high for the state to ignore. The financial industry is starting to see the instability caused by the current model. And most importantly, a new generation of fathers is entering the system with a different set of expectations. They are not willing to be visitors. They are not willing to be just a paycheck. They are redefining what it means to be a man and a parent in the 21st century. As we reach the conclusion of this deep dive, we have to look forward. If the system is as broken as the data suggests, what comes next? What is the potential outcome of this 200-year evolution? In our final part, Part 10, we are going to look at the Great Reclaiming. We will analyze the emergence of the sovereign father and the movement toward a universal parenting right that bypasses the judicial autocracy altogether. We will look at the tools you need to navigate this history and how to build a legacy even when the system is designed to erase it. The autopsy is complete. It is time to talk about the resurrection of the American dad. Prepare for the finale of the masterclass. The resurrection of the American dad is not a miracle. It is a strategic maneuver. It is the transition from a man who is a victim of a 200-year historical trajectory to a man who is the architect of his own legacy. By 2026, the data has become clear. The old models of fatherhood are obsolete. The colonial patriarch is gone, the industrial breadwinner is struggling, and the secondary visitor is a role that men are increasingly refusing to play. To conclude this deep dive, we must analyze the final stage of this evolution, the rise of the sovereign father and the reclaiming of the abstract family. Imagine a man named Samuel in 2026. Samuel is a graphic designer living in a state that has not yet passed a 50-50 presumption law. He has just spent 18 months in the divorce machine we analyzed in Part 6. He has been subjected to the psychological parent theory, the financialization of his fatherhood, and the judicial autocracy. But Samuel decides to stop fighting the system on its own terms. He realizes that as long as he defines his family through the lens of a court order, he is a prisoner. Samuel begins to practice what sociologists call role expansion. Instead of waiting for a judge to grant him permission to be a parent, he begins to build a parallel infrastructure for his children. He uses the 2026 technology at his disposal to stay present in the digital cracks of the day. He records videos of himself reading bedtime stories and sends them via an encrypted link. He attends every virtual parent-teacher conference, not as a guest, but as an informed lead parent. He documents every interaction with a level of precision that makes the bumbling dad trope look like a relic of a distant past. Samuel is moving from the status of a litigant to the status of a sovereign. He understands that the abstract concept of family is something he must define for his children, regardless of what is written on a piece of legal stationery. Step by step, the modern father in 2026 is bypassing the traditional gatekeepers. We are seeing a historical trend called the Great Migration of Fathers. Men are moving their businesses, their lives, and their tax bases to states like Kentucky, Florida, and Arizona, where the law recognizes their inherent right to 50-50 parenting. This is a massive shift in the U.S. landscape. It is the first time since the Industrial Revolution that men are moving specifically to prioritize their domestic role over their professional one. This movement is putting pressure on the states that still cling to the discretionary model. When a state loses its high-earning, tax-paying fathers to a neighboring jurisdiction that values equal parenting, the administrative state is forced to reevaluate its fiscal priorities. Let's look at a case study of a group of fathers in 2026 who formed a legacy cooperative. These men realized that the isolation of the divorced dad was a tool used by the legal system to keep them compliant. By pooling their resources, they hired forensic accountants to audit state Title 4D agencies. They found that in many cases, the financial incentives for the state were being prioritized over the welfare of the children. They took this data to the state legislature, not as angry men but as informed stakeholders. The potential outcomes of this collective action are already being seen in 2026 with the introduction of transparency bills that require child support agencies to disclose their federal incentive targets. This is how the abstract family is reclaimed. It is reclaimed through data, through collective action, and through an uncompromising commitment to being an equal presence. But there is a deeper psychological level to this resurrection. The divorced dad in 2026 is learning to master what is known as cognitive reframing. He is moving away from the trauma of the visitor label. Historically, if a man was told he only had 4 days a month, he would internalize that as a measure of his importance. The 2026 father rejects this. He understands that influence is not a function of time, but of quality and intentionality. He becomes the source of moral, physical, and intellectual development in every second he has. He turns a 4-day visit into a 4-day masterclass in heritage. Imagine if every father in America understood the historical levers that were used to sideline them. If you know that the tender years doctrine was a Victorian invention and not a biological law, you stop feeling guilty when a judge uses it against you. If you know that the best interests of the child standard is a mirror for social bias, you stop taking the judge's ruling as a verdict on your character. This knowledge is the ultimate shield. It allows the father to remain emotionally stable and present for his children, even when the legal battlefield is chaotic. The historical trends of 2026 show that as fathers become more informed and less reactive, the high-conflict divorce industry begins to starve. When a father refuses to play the role of the angry, secondary parent, the machine loses its fuel. The lawyers have nothing to litigate. The custody evaluators have no pathology to report. The state has no reason to intervene. The goal is to become so competent, so present, and so stable that the system becomes an expensive and unnecessary formality. This is the definition of the sovereign father. He is a man who parents from a position of inherent authority, not state-granted permission. As we conclude this 10-part masterclass, we must look at the final synthesis of our analysis. We have traced the father's journey from the legal son of the colonial era to the marginalized guest of the 20th century, and finally to the digital strategic parent of 2026. The abstract concept of family has been stretched, broken, and reassembled. What remains is a new model, the dual-anchor family. In this model, the father and mother are two independent, equal pillars. They may no longer share a roof, but they share the burden and the glory of raising the next generation of Americans. This new model is the only way forward. The data on fatherless outcomes is too overwhelming to ignore, and the spirit of the modern father is too resilient to be crushed by a billable hour. The resurrection of the American dad is a return to the foundational idea that a child needs both roots and wings, and that a father is the primary provider of both. You are not a visitor. You are not a paycheck. You are the link in a chain that stretches back centuries and will continue long after the current legal systems have crumbled. We have dissected the machine. We have analyzed the history. We have exposed the incentives. Now, the question is no longer what the system will do to you, but what you will do with the time you have. The abstract concept of family is finally being brought back down to earth, into the homes and hearts of the men who refuse to be erased. Even though this masterclass on the history of the American father concludes here, the real work is just beginning. There is a hidden layer to the family court system that we haven't even touched, a mechanism of surveillance and social credit that is being tested in select jurisdictions right now. If you thought the digital prison of geofencing was the end of the story, you haven't seen what is coming in the next phase of the administrative family. Prepare yourself for the analysis of the surveillance state and the future of parental privacy. The landscape is shifting again, and only the informed will survive the next wave of social engineering. Stay tuned for the next deep dive into the 2027 legal horizon.